Okay, sorry for this. We are back.
Okay, no problem. So as mentioned, I work for Johnson & Johnson. I'm in the law department. I'm a regulatory lawyer, and I have been involved in MDR since the start of the proposal, including on some specific aspects on economic operators. So yeah, let's start with the background, because I think, obviously, economic operators, medical devices have always had economic operators, and I think the big change is more how they are regulated. As many of you probably know, the previous, or the existing, actually, medical device directives, all three of them, they specifically regulated more the manufacturer and the authorized representative, and probably not in a very extensive way, like many aspects. That doesn't mean that economic operators were not regulated, but more that it was more likely that you could have rules at the national level. And I do think that many member states in the EU had some specific provisions on economic operators, for example, on distributors often. And that is now, of course, the big change, that from the future, from May 2020, the Medical Device Directive and also the IVD, Medical Device Regulation and the IVD Regulation will have these specific rules and roles and responsibilities for the different economic operators. And those are then the manufacturer and the authorized rep, like they already existed, but on top of that, importers and distributors. And of course, then we'll go into that a bit as well. There's also the new role for the person responsible for regulatory compliance, which is a very lengthy name, I think. And I think one of the main goals for having this is really that there's some sort of continuous control along the supply chain. Basically, if you imagine a product being imported, that means that the manufacturer still has the overall responsibility and is still the main responsible entity, I think, for any medical device. But then you will have the importer, and he needs to check certain aspects. So he's doing some sort of check upon how well the legal manufacturer is fulfilling his obligations. And then if the product moves on to a distributor, you will have the distributor doing, again, some check on whether the manufacturer and the importer have done or fulfilled their obligations. So you're building in some sort of policing within the supply chain of products. And I think the principle as such of that is a good thing. Let's move on to the next slide. And this is new to the medical device regulations, it's really part of a more general strategy of the European institutions to foresee harmonized rules, sector rules for different sectors, basically. So it's based specifically on the new legislative framework. And we've seen, this is new to devices, but it has been already adopted for different other legislations. And as listed there, the whole idea is that whenever we're going to revise legislation, sector-specific legislation, that we would try, that the legislator tries to use the same principles for that specific sector legislation, but with the possibility to deviate from those general rules if that specific sector requires, or if that is good for that specific sector. And that has come up, I think, at some points during the legislative procedure for medical devices, although some aspects are a bit different, and you will see that in most legislations. But of course, there were certain aspects, I think, that we tried to change even further that we didn't succeed in. And we'll come back to that when it comes to the importer labelings. I think if you look at more recent legislation where this was adopted, I think the cosmetics regulation and the biocides regulation already have similar rules. I personally am involved quite a bit in the cosmetics regulation, and the experience so far, I think there as well, there was some industry was maybe a bit skeptical or afraid about how this would play out in practice, because all your customers will have specific obligations, that means it's very likely that they will start raising questions to you, asking for more documentation. So that will happen. And I think it's mainly going to be important sometimes basically to clarify to them that their role is still very specific and what they need to check is a limited type of information, because I think there is a risk that some customers may want to go further and in essence double check on your conformity assessment procedure, and that is not the intention of this legislation. But that is something that we need to, I think as an industry, keep an eye on, and if need be, develop guidance and discuss this with, associations representing customers, basically. Let's go to the next slide. So, and then one thing that is also, I think, important to keep in mind is that if you look at that new legislative framework and how it's being implemented, it probably is mainly intended and makes most sense for situations where you have manufacturers, importers, and distributors that are independent from each other. Because then you really have a sort of independent check of the compliance of the previous actor. But the rules apply to entities or persons that fall within this capacity. And that means that they also apply to multinational companies. And I think most multinationals will have all sorts of actors within their group. It's very likely or very possible that you have a legal manufacturer outside of the EU. You then obviously have an authorized rep as well, which may be one of your own companies. That product gets imported by another entity within that group of companies, so that entity will then become an importer, and the product may then be distributed by the different national companies in the countries, in which case all these national operating companies will be distributors. And I think each of them will still have to fulfill the specific obligations on these actors. I think especially at the distributor level, there's probably some room for working together, but I think it's mainly important that you are able to show that there is still some check taking place. Because the whole concept, of course, of these type of entities within the same group of companies policing each other is a bit, you could arguably it's a bit strange, because you wouldn't want, of course, one of your operating companies to go and tell out on the legal manufacturer that is part of the same group. I think if I look at the practice in our cosmetics industry, I do think actually most authorities will realize that the situation is a bit different in a group of companies, and that in essence these companies, they work together, and they also work together when they need to approach authorities. But strictly speaking, each of these entities will have their own obligations. And then of course the same legal entity, you could have a different status as economic operator depending on the product involved. I mean, you could be a legal manufacturer for some product, but at the same time distribute products from another manufacturer. And then in that case, you will have to make sure that you fulfill the obligations as distributor for these other products. And then lastly, as last slide of introduction, I think a lot of obviously the text is new for these new economic operators, for importers and distributors. Some of the other elements for the other operators has changed. And I think a lot of it is maybe still a bit unclear on how exactly it needs to be implemented. So there is actually room for, I think, for industry as well to provide some proposed guidance. But there is also a very important document out there already, which is the Commission Blue Guide, which is basically on this new legislative approach or on the EU product rules. It's a very extensive document, and it provides a lot of guidance. I mean, that was already the case. That's already the case for the current directives. But it also has important parts on economic operators specifically and how they need to, fulfill their role and their obligations. Let's move on to the next slide. Hurry up a bit. So looking at which are the economic operators. So, we already discussed them, I think the manufacturer, obviously the one who manufactures or has the product manufactured, so basically the legal manufacturer, still the main entity responsible. Then the authorized rep who represents the manufacturer, if the manufacturer is based outside of the European Economic Area. And then obviously, then the next one, the importer. And the importer is really the one that places the device on the EU market. So there's an import taking place, and placing on the market is the first making available. And I think what's important here to understand is that the rules on placing on the market, they don't just apply to a type of product, but to every single product. Every single product is placed on the market at some point in time. It also means that, it's perfectly possible for one legal manufacturer to have 2 or 3 importers of the same device. If each of them import products physically into the EU, they each will qualify as importer, and the 3 of them will have to comply with the obligations upon importers. And then, of course, the next one, the last one, is a distributor, and that basically he will be an entity that makes products available to others, and he will source these products either from the importer if they're imported, or from a legal manufacturer. And the obligations obviously become a bit less if you go down in the supply chain. Although I don't think there's that much, arguably not that much difference between distributor and importer. Okay. Let's go to the next slide. A few words maybe on manufacturer liability. I mean, I didn't include a lot of extra slides on manufacturers because I think if you look at the MDR and the IVDR, there is more explicit language on what the manufacturer obligations are. But I think all in all, I mean, it's very much aligned in principle with with the medical device directives. What is very new, though, is the provision on liability and the obligation to have, well, not necessarily in insurance, but at least sufficient financial coverage in place. And it's something that we worked on as an industry during the legislative history as well. I think in principle, we tried to defend, I think, that product liability is actually governed by the Product Liability Directive, and that access to evidence is covered by the civil procedure legislation, which is still member state competence and subject to member state rules. And I think that work led to some improvement in the text, but it didn't, there's still some very specific provisions in, and especially the one on access to evidence is not an easy one to interpret, and probably not the best example of how good legislation is written. Because basically it gives a specific task to the competent authorities to assess basically potential damage claims. And if they have a reason to believe that the device may cause the damage, upon request they should provide the injured patient or some of the other parties listed there access to the technical file potentially. And it has an exception for data protection rules, which I think are probably an intellectual property rights, which is actually intended to refer to confidentiality issues, but it refers to IP rights. And the only exception I think we managed as an industry to build in is that the competent authority need not comply with this, where disclosure of this type of information is normally dealt with in the context of legal proceedings. Now, that is normally dealt with in the context of legal proceedings. The strange thing is they need not comply. It almost is written as it gives them an option to decide whether they will comply with it or not. And what is facilitate access to this information? I mean, can they order or can they oblige the legal manufacturer to open up the technical file? It's a very unclear provision, I think, and I do think as an industry that we need to expect that plaintiff lawyers, insurance companies will try to rely on this to try to get access to the technical file. So maybe something that within MedTech we need to consider what position we take on this. And then at some point during the legislative proceedings, I mean, there was a call for mandatory insurance that each legal manufacturer had to take out. That was changed. Actually, I think there was some criticism from the insurance industry itself that the way it was written was almost impossible to obtain that type of insurance. So it got changed a bit, but in any event, each legal manufacturer will have to consider how you're going to show that you comply with the requirement to provide sufficient financial coverage in respect of your potential liability. I think you can do that if you have a good insurance, but I think what's important is that it allows freedom to companies to show how they provide it, so it doesn't necessarily have to be insurance. I mean, some bigger companies may be self-insured, but it is something to consider for the implementation of MDR as well. So that on manufacturer liability. So let's move on then. I probably need to speed up a bit. To the authorized rep. I think if you take into account the medical device directives and the MedDev guidance that is already there, maybe not that many changes. I mean, the principle is still the same. If you, as a manufacturer, you're not established in a member state, you need to appoint an authorized rep. I mean, now the regulations itself will specifically foresee the minimum list of tasks that the authorized representative needs to have, but also a specific list of obligations that the legal manufacturer cannot delegate. And I haven't copied everything into the slides, but it's actually fairly clear, I think, if you look at the legal text. I mean, the minimum list, for example, will be that the authorized rep needs to verify that the declaration of conformity and technical documentation have been drawn up and that the appropriate conformity assessment procedure has been carried out. It needs to have a copy of the technical documentation available. I think in this age of electronic access, typically that's not so difficult to foresee. And of course, complying with the registration obligations himself. I think there's still some freedom. In essence, I think there's still freedom for legal manufacturers to decide what tasks to delegate or not. It's just that you have to keep in mind that there is the minimum list of tasks that he needs to have, but there's also a list of tasks that you cannot delegate. That doesn't mean maybe that they can't assist at all, but obviously that obligation rests with the legal manufacturer and should stay there as an obligation. Let's move to the next slide. New as well, but I think this was also already covered by the MedDev guidance, but now incorporated into the legislation is specific rules on how to change authorized representatives. Probably not something you want to do quite often because it will cost you a lot of money if you have to change the name on all your labels, but it can happen. And what it foresees is that you should try to have an agreement between the manufacturer, the new authorized rep, and where possible, the old authorized rep, and agree basically on some sort of transition plan until when basically you can use the name of the old authorized representative on the label, potentially promotional materials, how the documents will be transferred, etc. Obviously, I think that's an ideal scenario. I think legislation itself says where practical, the outgoing authorized rep should be included because, of course, you can't force him. And if you end on not good terms, it may not be easy to include him in an agreement. There will be a bit of a case-by-case assessment. But I also think that, especially the multinationals will probably try to often use one of their own companies as authorized rep, in which case this is less of an issue, of course. And I think there's more reason to consider that because there as well, another word on liability. There's also a specific provision now on product liability for authorized representatives, basically saying that, if the manufacturer is not established in the EU and he has not complied with any of with his obligations, which arguably, if you put a defective product on the market, you can I'm sure a plaintiff lawyer will say that's the same as not complying with your obligations because you shouldn't put a defective product on the market. That the authorized representative is basically liable in the same way as the manufacturer. I think the reason for this liability could be questioned. I mean, here as well, I think industry tried to argue that the product liability regime is regulated separately and applies in full to medical devices, like it also applies to other sectors, and it already has a sort of cascade of who's the responsible, the responsible entity in case of product liability, because it is in essence the manufacturer or the importer. And if the importer cannot be identified, then it could be the distributor. And what the legislator now has done is basically introduced a new economic operator who could be potentially liable for product liability, and that is the authorized rep. Now, given the system that is already in place under the product liability rules, that wasn't really necessary, and it obviously risks. It may affect a bit the relationship between the authorized rep and the legal manufacturer, because the potential liability that an authorized rep could now have, if you are authorized rep for some more high risk class 3 products, could be very big. They will have to take out appropriate insurance, or at least see how they could financially cover this as well. And they may be more worried in how you did as a manufacturer, how you did your conformity assessment procedures. So it may lead to more checks by them as well. But it is what it is, and it was adopted as such. Okay. So that concludes a bit the authorized rep. Like I said, I think especially the liability part is very new. Okay, let's move to importer. Am I doing it on time? Yeah. I'm going to hurry up a bit so that there's time for questions maybe. So, importer. So, a very specific list of specific obligations that the importer needs to do before he places a device on the market. And I think both for importers and distributors, that's basically how you can look at it. They both have some things they need to check before they place a device on the market, and then there's some ongoing obligations on both parties, importers and distributors, in how they basically should cooperate with the vigilance and the market surveillance part. And obviously both of them also need to ensure proper storage and transport, which is very logical. So importer, if you look at it, what's interesting is that the way it's phrased, it's not easy for an importer or for a company to import products without actually having some sort of connection with the legal manufacturer or the company behind the product, because otherwise it's going to be difficult to actually implement his obligations. So he needs to check that the product is CE marked, that the declaration of conformity has been drawn up, obviously a manufacturer identified, authorized rep designated, that the device is labeled in accordance with the regulation and accompanied by the IFU, that the UDI has been assigned, and that it's registered. And an importer needs to register himself in UDAMET as well. That's different for the distributor, where it's more that the member states can continue to ask registration. So, fairly clear, I think, list of tasks. I think it's again, if I can make the comparison with the cosmetics regulation, which has a similar list of tasks because it's also based on the new legislative framework. I think you need to look at it that he needs to comply with this checklist with the information he has. Because if you look at the device is labeled in accordance with the regulation, I think it's more checking that all the elements that are required in labeling are there and that the language is correct for the countries intended, where the product is intended to supply. I don't think an importer needs to go and check in detail that every single warning that ought to be on is on. It's not the intention that he that the importer redoes the conformity assessment procedure. So it's not that he needs to check everything in the greatest possible detail. And that's a bit how I've been using it in the cosmetics industry as well, and it seems, it is accepted there as well. Let's go to the next slide. And then specifically as well, importers must indicate their name and address on the device, packaging, or a document accompanying the device. And this is one of the areas where I think we as industry try to convince the legislator that this is an area where there is good argument to deviate from the new legislative framework, because that is foreseen there as well. Because we already have, in any event, an EU entity labeled on the device. If it's not the manufacturer, then it's going to be the authorized representative. So we try to argue that there's no need to add yet another person, because for now, for imported products, you will list potentially up to 3 entities: the manufacturer, authorized rep, and importer. We also thought that for vigilance reporting, it actually would be clear to have just one EU-based entity listed, but it wasn't accepted and it was kept. So we'll need to make sure that your importer is the contact details are included in one of the 3, in one of the 3 ways listed there. Now, but it's also important to keep in mind that the supply chain structure, etc., doesn't always fully follow how the regulatory structure is based. And I think there's an important exception there. And it's listed, and this is copied actually from the Blue Guide, so it shows that it's a useful document to look at if you have any questions. Because you might have situations where your product is physically manufactured outside of the EU, let's take the US, so it is then also physically imported. But you might have your legal manufacturer based, let's take Belgium. Now, strictly speaking, from a customs point of view, there is an import taking place, but from a regulatory point of view, this does not qualify as an import because you have an EU-based legal manufacturer. And the Blue Guide itself confirms that in such a case, they only consider that there's a legal manufacturer and distributors, and you don't need to worry about the importer obligations. So I think it's a useful rule to keep in mind, that there might be cases where you don't have to follow the importer obligations. Let's go to the next slide. And then, as I mentioned, I think the other provisions are probably more linked to after he placed the device on the market. He needs to cooperate in all the market surveillance and vigilance part of it. So it's keeping a register of complaints, non-conforming devices, and recalls and withdrawals. If he gets information about suspected incidents, he needs to inform manufacturer and authorized rep. If the importer believes that the device placed on the market is not in conformity, he needs to inform the same entities, manufacturer and authorized rep, and cooperate to ensure implementation of any needed corrective actions. And if there's a serious risk, also to inform the competent authorities and the notified bodies. He needs to keep available a copy of the EU Declaration of Conformity, and if applicable, the relevant certificate. And I think here that shows if there's no connection with the manufacturer, it's difficult to comply with this, because you need to be able to get the copy. And in principle, there's no obligation upon legal manufacturer to just provide a copy of it to everyone that wants a copy. Obviously, storage and transport conditions, and cooperating with authorities on any required actions regarding devices placed on the market. And then free samples or access to the device, probably more in case of capital equipment, etc. Yeah, let's move to the next slide. So now quickly on the distributor obligations, and I think, as mentioned, they're very much aligned, and mainly structured in the same way, checking certain things before you make a device available, because the importer places it on the market, the distributor makes it available, and then continued obligations that are more linked to storage, transport, market surveillance, vigilance, etc. So a bit similar, distributor, that the device, you need to check that the device is CE marked, the EU Declaration of Conformity has been drawn up. I don't think that means that he needs to have a copy. That's really the importer that should have a copy. Again, device accompanied by the information to be supplied by the manufacturer, and then linked to obligation of the importer for imported devices that the importer has basically provided his contact details. Of course, that assumes that the distributor will know that it's an imported product, and that where applicable, that the UDI has been assigned. What is important here as well is that for distributors, it's clarified that with the exception of the importer labeling obligations, they can apply a sampling method. But it also means that importers are expected to do this for every single device, while distributors can apply a sampling method. And then if you think about more the context of a multinational company, I mean, I think you could envisage applying a sort of sampling method that is similar, or basically one sampling program that is done for all, or for a group of operating companies. I think there is some flexibility in how this is implemented. I think it's mainly important to show that you have a clear, probably some sort of quality management system to implement these obligations. Let's move to the next slide. And then the additional obligations. Again, I think no need probably to go through this list, because I think it's a very similar list to the importer obligations, and it's linked again to vigilance, market surveillance, storage and transport conditions, and also a clear obligation for when the legal manufacturer initiates a corrective action or a field action, an obligation for them to cooperate with the manufacturer and the authorized rep. Now let me see whether there's anything special. No, because and here again, maybe if you look at not the last one, but the preceding one, it shows again the difference a bit between importer and distributor. So the distributor needs to provide the competent authority with the information at their disposal to show compliance of the device. But it's indicated as well that this obligation is met if the manufacturer authorized rep provides the info. Okay, let's move on to the next one. Now, again, based on the new legislative framework, there's this provision on what activities will make an importer or a distributor a legal manufacturer, him or herself. And I think basically, if you make a device available under your own name, if you change the intended purpose of a device already placed on the market or put into service, or if you modify a device placed on the market or put into service in such a way that compliance with the applicable requirements may be affected. And I think it's a separate question whether there might be other legal issues if you do this, because I think there might be. And in that sense, I think, 1A, making a device available under your own name is also an easy way to qualify as legal manufacturer. But I think it's also mainly intended to make very clear that if you do any of these activities, that you will be held basically accountable for it and need to ensure full compliance, and that if you can't, you have an issue. But I think what is even more important is that we now have very specific rules on parallel trade within the EU. I think, as many of you may know, there was already some case law, especially in the IVD area, I think, that was already, in essence, applying the case law that is being applied for medicines. And this is, I think actually that Court of Justice judgment already looked at the language that was in the then proposed or pending MDR and IVDR proposals. And let's move to the next slide. Okay. So, like I mentioned, it's inspired by the medicines case law, and it really follows the same principles that, in essence, EU is in favor of parallel trade to the extent it's justifiable, and that we operate in a single market, so parallel traders should be given some flexibility. So what is covered? Basically, if a parallel trader translates labels and IFUs or changes packaging necessary to market in the targeted member state, these activities themselves will not make that parallel trader a legal manufacturer. And in essence, in principle, he probably remains perhaps an importer, but at least a distributor. and needs to comply with these obligations. And I think especially, obviously, one, to the extent that you have products with multiple language on it, obviously any distributor can ship these freely between the member states that are covered by the languages, and he's not in the spirit of the new regulations will not fall under this provision. It's really only when he translates and ships it to another member state or changes the packaging. And I think changes the packaging is probably an area where I could see room for discussions between manufacturers and parallel traders, where there is whether the packaging, the changes are really necessary to market in the targeted member state. A good example would be you have in one country you market a pack with 6 units, in another one a pack with 3 units. The parallel trader will say, well, I have to split these up to a pack with 3 units for the other country if I want to ship them there. What is important that if you touch the sterile condition, that doesn't fall under the special rules for parallel trade, and then you will become a legal manufacturer, basically. Now, what is required, and again, I think it's very similar to the medicines field. Well, they must indicate their name on the product. They must have a quality management system, but only for the relevant activities. So if you only translate, then basically your quality management system will have to cover these activities to show that you guarantee appropriate translation into the another language. And you have to inform the manufacturer and authority in advance, and I think it's 28 calendar days, which is actually a bit more than in medicines, I think. And they have to inform the authority of the quality management certificate as well, but not the manufacturer. And you can request a sample. And I think the idea of requesting a sample is to check whether your trademark rights are affected. Was the repackaging done properly, etc. Okay, how much time do we have? I'll hurry up because we don't have that much time left, I think. Then, 2 last topics. One is the person responsible for regulatory compliance, and I think it was initially called more qualified person as well, which I think is a more catchy, shorter title, but so it applies to manufacturers and authorized representatives, and I think interestingly, for the manufacturer needs to have him available within the organization, and an authorized representative and also SMEs actually need to have it permanently and continuously at disposal. Available within the organization, I think in principle it could be interpreted as you need it basically full-time available, while permanently and continuously at disposal allows you a bit more freedom, and you can work with somebody who's a consultant on a part-time basis, for example. But interestingly, if you look at the legislative history, the language and the difference in language used was specifically done to argue that available within the organization means that it needs to be employed by the manufacturer. And I think, something that maybe as an industry we still need to discuss, especially if you think about, again, the multinational, what does that mean? Does it need to be specifically the legal manufacturer, the entity that is the legal manufacturer that needs to employ that person? Can it be not another entity in that group of companies? Does it really have to be an employee? If you look at the medicines world, I don't think it needs to be an employee for the big marketing authorizations. So maybe still some room for looking into that. There is a specific required expertise, but I don't think we need to go into those details. And what's important as well, and we'll go on the next slide, we'll show what is intended here, what the tasks are, but a manufacturer, you can appoint different people for different tasks. Okay. Yeah, let's go to the next slide. So it shows a bit. This is specifically the list, I think, for the legal manufacturer. So that person must be responsible for at least a task listed here. It's basically checking conformity of the device before it's released, that the documentation and the declaration of conformity are drawn up, kept up to date, that the post-market surveillance obligations are met, etc. How it needs to be implemented, I don't think that's necessarily fully clear. It's yet also not clear from the MDR, but I think it's mainly important that they have some sort of oversight role and within your system, how you organize it, that they take responsibility for this. So, I mean, obviously, they will need to be able to work with teams to fully implement this. What is interesting, I always felt, is that the authorized rep needs to have a person responsible for regulatory compliance as well, but the regulations actually don't go into detail and what the tasks of that person are. I mean, you could almost interpret it that it has the same tasks, but I don't think that would be correct. And I think it has been discussed by now that obviously the person responsible for regulatory compliance, long title, for an authorized rep, actually his tasks should be, aligned with the specific tasks of the authorized rep. And there, as discussed, there is actually some freedom in what you give the authorized rep. There's a minimum list and a list of excluded issues. And I think the tasks will have to be linked to that specific situation, but not necessarily the list of tasks that exist for a manufacturer, I think. And then obviously you can't, as a sort of protection for the independence of this person, he cannot suffer any disadvantage for the proper fulfillment of his or her duties. Let's move on. One last point. Or should we skip it and go to questions? We do it. There's also a new provision on distance sales, which I think is interesting because I think it's probably one of the first sectors that I'm aware of where you have this specific provision. And it's basically saying that if you offer a device by information society services, or basically the internet, to a natural or legal person established in the union, you need to comply with the regulation. And there's also provisions for diagnostic therapeutic services offered online. And I think it's intended to provide enforcement authorities with a more clear legal basis to enforce the rules. Because of course the big question then is, what is offering to a natural or legal person established in the union? That is not clarified in the regulation, but again, you can go to the Blue Guide, and it has actually since 2016 some additional new language, and the view of the Commission is fairly extensive. The moment you are accepting a currency, an EU currency, if you are accepting to ship it to an EU country, you're considered to offer it to a natural or legal person established in the Union. Competent authorities have a bit of specific enforcement powers. They can request a copy of the Declaration of Conformity, which again is quite interesting because we looked at the obligations for importers and distributors, and importer needs to be able to make available a copy of the Declaration of Conformity, but the distributor not necessarily. But if you are a distributor and you're offering it online, you actually can request this. Although I do think you can refer them to the manufacturer and authorized rep then either, but that should be possible. And they can, on grounds of public health, require the provider to cease the activity. So I think it's mainly, the principle as such is probably not new, but it's intended to provide a more clear basis and more clear specific enforcement powers. And I think that's probably one of the main issues. I mean, enforcement will remain the biggest hurdle for any online sale, and that's not unique, I think, to medical devices. So that was, in 45 minutes, a general overview of economic operators. So we did get some questions through already, and let's go through them. And some of them we've touched upon already. So can a same economic operator have different roles? And I think we touched upon that, yes. It really depends on how you're organized and what you do. You could be an importer for some products that you get from outside of the EU, but you could be a distributor for some others, and you can be a legal manufacturer and a distributor at the same time as well. I mean, obviously, and if you're an importer and a distributor, well, if you just have one system for importers, it probably covers your obligations for a distributor as well. So I think how you implement that, you need to see for yourself a bit. Should manufacturers or authorized rep map its supply chain and contract all actors? Well, I think when it comes to economic operators, the obligations are also on the specifically distributors and importers. I think it's good. You should have a good idea of how your supply chain look like if you want to implement all of this, especially multinational companies, because a lot of your legal entities in the EU will have a specific role. I don't think it goes that far that you necessarily need to contract all actors, because you will have, if you have an importer that works with distributors, there will be a contractual relationship between your importer and his or her distributors, but it doesn't mean that as a manufacturer you need to start contracting with the distributor. So I don't think it goes that far. So can a manufacturer have several importers for the same device? I think we touched upon that as well, yes, because I think it's important to always remember that the concept of placing on the market is not linked to a type of device, but really to every single unit. So if you have a type of device being imported by 3 different legal entities, then you have 3 importers, and each of these importers will have to comply with the obligations upon importers. Next question. At what point is a product considered placed on the market? I think we need an extra session for that one, maybe. But, well, I think, remember that placing on the market is the first making available of a device. And there's a great, there's a lot of guidance in the Blue Guide, and I think in 2010 there was specific guidance adopted for the medical device sector as well. I think that is good. That will provide you with good guidance. I think in principle, it's the first supply on the EU market. And a general rule as well is that just having the products in the stock of the manufacturer, even if that's within the EU, doesn't count as placing on the market yet. And I think one of the reasons for that is that if you then have a new obligation, there would be a bit too much of an incentive for manufacturers to do stockpiling in their warehouse. So there needs to be some offering that took place already. Ideally, your product has been sold to the next person in the supply chain, but it doesn't necessarily have to go that far every time. But again, I would recommend reading that 2010 guidance and the Blue Guide for more details. Especially on imports, it's not always clear when you can consider something placed on the market. Next question, which responsibilities can a manufacturer delegate to the authorized representative? Well, I think we've covered some of them in the slides. I think important, there's a minimum list of what you need to be able to let the authorized representative do, and there's a list of excluded issues. And besides that, that's a bit flexibility that you have between the 2 parties to agree on how you want to operate. Then, do distributors who translate the IFU need to have a certified quality management system? Yes. I think we touched upon that. What's mainly important is, do they limit their task to translating and or changing the packaging to market the product in the country of destination? Then they fall under the special regime for parallel traders, and their quality management system can be limited to those specific activities. If they don't fall under that and they do more, they probably could arguably become the legal manufacturer, and then obviously there's a different set of rules that apply, and you can maybe also question actually whether they can do these activities based on other grounds. Last question we have here, when the importer or subsidiary receives devices, must they physically check each new batch, each new receipt? Well, again, I think they're important to make distinction between importers and distributors, in that importers need to check these specific aspects for each device, each new device type, I would say, they place on the market, while distributors can do sample checking. I do think even an importer, while I think for an importer you will have to be able to show that you perform that check for each new device, I don't think it needs to necessarily be interpreted that you need to recheck that every single aspect for each new batch of products. I mean, obviously, as an importer, I mean, I'm assuming that you do some basic checking for every new batch of products you get in. So you need to check, is this the same type of product, that we've checked before? And I don't think you then necessarily need to go and ask a copy of the declaration of conformity every time with every batch. But you would have to check that it's the same as the previous, as the product which you checked upon. Yeah, I mean, that's the list of questions we've had so far. Okay, so question, does the importer need to have its name and address on the device and or the packaging or a document accompanying the product? So I think it's probably a question of where should it be and can it be just on one? And I think you have an element of choice, but let me just quickly check the language specifically. So you need to provide it on the packaging, on the device, or a document accompanying the device. So you can choose. And I think that's an important distinction because there's some other legislation that really gives priority to one over the other, and it's more when it's not practically feasible that you can choose the other. But, and I don't have the RoHS chemicals restrictions legislation here with me, but actually that one applies as well, has a similar obligation. So when you do it, you need to check the language of the RoHS legislation as well, because if that deviates, you have to comply with that as well, probably. But in principle, under the regulations, you can choose where to put it. Okay, so a question, is it possible to have a third-party logistic provider in Europe be an appointed authorized representative for a U.S. manufacturing company? Well, yes. I mean, in principle, a third-party logistic provider could play that role, but I'm not sure they're typically set up to play that role. Because if they do, of course, they will have to be able to comply with all the obligations. They will need to have a person responsible for regulatory compliance. But if such third-party logistic providers can organize themselves in a way and provide all the necessary services, then in theory it's possible for them to play that role. There's no specific restriction on who can play the role of authorized representative. But I think typically today they would probably not have these capabilities yet, most of them.
Thank you to Mr. Van Passel for his great presentation, and thank you for following our webinar. The materials will be sent to the participants soon, and we will keep you posted about our upcoming events. Once again, thank you very much for your presence.